If we want Australia to regain leadership in human rights, here's a suggestion. Right now, we see a world where corporate rights subordinate human rights and actually trample on them, especially with these secret negotiations in the TPP. Shouldn't we, when we endeavor for a Bill of Rights, reassert the supremacy of the rights of a human being over corporations and end this insanity once and for all?
I think the answer to that, of course, would have to be yes.
How?
But how? Well, because I think it would be implicit in the legislation that, I mean, the rights that are being preserved are individual rights, and
Isn't that in the US? So, shouldn't that be assumed in the US Bill of Rights?
Sorry, say again.
Shouldn't that be assumed in the US Bill of Rights as well?
Well, it is. The problem we have is that and I was just talking to someone before, we're not going to get a perfect system. We are a democracy. There are going to be faults in it. Sometimes it's going to fail. Let's hope a lot of the times it doesn't. It won't be a perfect system. But what this is about is making sure that the system that we do put together is a lot better than what's happening at the moment. But I think in answer to you, the answer is yes, of course, but it should be implicit in legislation that when you're coming up against a corporation, effectively it's the individual that's coming up against the corporation.
I've got a question about Dr. Mohammed Hanif, who the Johnny Howard government tried to stitch up to make the Australian public think you can't only trust average Muslims, you can't trust professional Muslims either. Doctors, lawyers, whatever. But the case unravelled and fell apart shockingly when he had a courageous lawyer and someone from Australia who let out a bit of truth. And I believe the Howard government had secretive laws in place as well to try and prevent the truth coming out. So stitched up terrorists could get their day of justice. What's the change now with Abbott's new laws, 2 years jail or 10 years jail, I believe, for journalists or whatever? If a lawyer representing a terrorist nowadays had a client who was not guilty of any crimes that they knew of, and they did the same as what Hanif's lawyer did, and the journalist from Australia, would they get as much tracked these days, or would they get shoved off in jail and would everything be hush-hush with secrecy and...
The one consistent thing with governments in any country that abuse human rights is that they like to do it in secret. And so the introductions of the laws in recent years that have been about both secrecy and immunity from prosecution, I think are extremely dangerous. So, for example, the laws that say, and the perfect example of this really has been the recent scandal, the recent issue about the payment of money to boat crews to take asylum seekers back to Indonesia. And if you look at the way that's played out, it became a media issue, but it killed the media following of that issue when the government leaked that the person who had done it was an officer of the Secret Intelligence Service, and that therefore they were indemnified against carrying on against any prosecution for an illegal act. And at that point the media essentially had two issues to face. One was that even if it was found that it happened, the person who did it is indemnified against their criminal behaviour. But secondly, the media also had to think about what the laws now say about them disclosing what happened, because it was an operation of the intelligence service. And we now have laws that say if you disclose an operation of an intelligence service, you could face jail. Now the media weren't threatened with it, but you notice how quickly that issue died out of media coverage, and that's the self-censorship that those sorts of laws impose on the media. The media stops reporting things in the first place because of the threat. And when you combine secrecy laws with impunity laws, that's when human rights abuses flourish. And we are heading down that road. We have had laws in recent years that have done both.
I felt kind of frustrated when you guys were up there talking and said the US does it, New Zealand does it, the UK does it, all these do it, why aren't we doing it? And I feel as though that is not a good reason to ever do something, just because other people are doing something, just because the US feels like we're doing something great or we're doing something big. Like, let's hop on the bandwagon. I feel like that is so, it could be like a twisted way almost of like, as we were talking about, like bullying almost, you know? But, I mean, don't get me wrong, I really do agree with everything you guys said, but that was just one like thing you guys said that just hit me the wrong way. So, if you want to comment on that, go ahead.
Well, in the case of gay marriage, but Asia doesn't.
Yes, you don't just do something because everyone else is doing it. And I hope that people will go away with the idea that, in my view, that's just one reason why you would do it, and perhaps, you know, there are other more important reasons. But human rights is an international issue. Human rights is about engaging with the international community. And it's very important, I think, for Australia as an international player, not to mention its history. Doc Evatt would roll in his grave if he heard Tony Abbott. But it's very important that we, as an international player, to be taken seriously and to consider our position in the world, adopt that position. I mean, that's, yes, because they're doing it, we should. We can engage then on a level about international politics, about human rights. At the moment, we are not taken seriously, and we have to be.
You referred to the forced closures of remote Aboriginal communities, and I was just wondering whether, given that impacted on their basic rights to water and electricity, do you consider that our basic needs, for example, to water, food, shelter and clothing, affordable housing, should be, primary perhaps in the, in discussion of a future Bill of Rights? And secondly, how inclusive would you like the process of forming a Bill of Rights to be?
On the question of remote communities, I think there is no doubt in a country like ours that rights should include rights to the basics of life, and they are, the food, water, shelter, etc. I think there's no doubt that they should form part of our rights framework. On remote communities, just to let you know, so Amnesty ran a campaign for some time on the Homelands campaign, which was about maintaining the right to stay on homelands. And we did a lot of research into that, as Amnesty tends to do. And what that showed was that those Aboriginal people who were living on their homelands had higher health outcomes, better quality of life outcomes than those who were forced to move into living on the fringes of regional towns. So it's not even a question, so there is like the cultural question, but just straight up on quality of life questions, there is no doubt that the closure of remote communities will actually decrease the quality of life, the educational outcomes, the health outcomes, and for those people. So I think that is a basic question of human rights, and it should be in the Australian human rights framework, undoubtedly. As to inclusivity, we do have to, it should be a process that allows everyone to feed into where we get to. There should be, and as I said, the Labor government did a massive national process of consultation and then ignored the findings. But that was a good example of how to engage. 35,000 submissions, they did meetings in every state and in remote communities and remote towns. And that should be repeated, because we should all feel ownership of our rights. And so whatever the instrument is, it should be an instrument that comes about through a process that gives us ownership over those rights.
I want to introduce the economy into this picture. I fully support the argument that has been argued so well about the role of the human rights legislation and a human rights charter. It's clearly been needed for some time. What I want to get you to think about and talk about is the engagement between the culture of a fair go, the mythology of that. But nevertheless, it's striving to be a fairer society in Australia. When you look at the economy, they don't engage very well. The legal system, I'm not sure where the legal system is, but it's sort of there in between. But there's also a political system. It seems to me that the real reason that the human rights legislation wasn't proceeded with under the Labor government, I mean, they were just weasel words that were used to knock it back. Wasn't the underlying reason the fact that it would open up billions and billions and billions of dollars in damages for the ills that have been done by Australians and other Australians over many generations? And look, just with regard to the apology, so there was the apology for the children who were taken away. No compensation. If the human rights legislation goes through, wouldn't that provide an avenue for suing the government for the damages that were caused by that process?
Those processes already exist. Governments, I have cases suing the government for stolen kids. Mr Trevorrow in Adelaide was one of the seminal decisions about getting compensation for being a child that was removed. So, in terms of whether or not a Human Rights Act would open up potentials for huge amounts of compensation, it's not something that I think is likely. In terms of native title, for example, a compensation regime exists for extinguishment of native title. That's something that hasn't hit everyone yet, and I'm telling you it will. There will be significant compensation to Indigenous people for the extinguishment of their native title, post-75. Those cases are yet to be run. Indigenous people are too caught up at the moment in trying to get their land back, but once that's all sorted out, the next dust that's going to be kicked up is going to be compensation cases. That's there. Human Rights Act's not going to make any difference about that. So kids that are taken, there's already an opportunity there. Just sue them, sue the government. That's happening. Will the Human Rights Act make any difference there? No, probably not. It's already available. But yes, if there's a Human Rights Act which provides for compensation for violations of human rights, yeah, absolutely. There will be a compensation regime. But the stats that I'm aware of, and I think also Chris talked about in the UK, the litigation that has arisen since the UK Act was something like 2%. Most things settle in mediation. So I hope I've answered your question.
Yeah.
How long before they'll get their day in court?
Who?
That case you just mentioned.
Oh, they're happening a lot. I mean, there are children that were subject to, most of them are mediated, but and people, you know, the big problem is evidence and you know, being able to prove things and but
Land rights is first.
yeah.
What about
Yeah.
now? Because there's more now than during the stolen generation.
More.
Children being removed from their families.
It's a very different debate at the moment. It's a
Will those kids have grown up by the time they get their day in court?
Well, the question is whether or not you'd be able to say that some of the Indigenous kids that are currently being removed from care or have been in the last 5 to 10 years, whether or not the circumstances were such that they should have been removed. Now, I don't want to get into that debate tonight. I do quite a bit of care work for parents, not for the department, but for parents.
Yeah.
But it's a very, very complex issue when you're dealing with kids that need care.
When we look at the history of the struggle for human rights and democratic rights, it goes back a long way. You mentioned the 40th anniversary of the Anti-Discrimination Act. It's the 800th anniversary of the Magna Carta.
Yes.
And in fact, if you look at the Magna Carta, I think we're going backwards from there. Do we have habeas corpus now? I don't know. I think you know, there's a lot of arguments that we've actually gone back from 800 years ago. My main question is relating to how do we put a Human Rights Act on the agenda, because at the moment it's not really on the, not on the central agenda. It's come up a couple of times or several times in Australian political history, but it's sort of pushed aside. I actually think that maybe we have an opportunity, because you have to have some political angle or some key issue, and I think the equal marriage issue is really important, because 80% of the Australian population, you've got to have a situation like that, 80% of the Australian population support an equal marriage law, and yet it's being blocked by the parliamentarians. So, or a good sector of them anyway. We've got to build up, that seems to me to be the political climate where we can build up the idea that we can't rely on the parliamentarians to implement democracy. And strangely enough, in the United States, we have an example where, believe it or not, democracy is implemented by the Supreme Court, which seems counterintuitive, but every now and again this is what happens. So I think we do have an angle there that we can start to say, here's a denial of democracy, the politicians will not allow it, we need a legal mechanism, some kind of Human Rights Act, probably not a Bill of Rights in this situation, but a legal right.
I just might make one comment, which was about how do we get it on the agenda, which I think is really important. There is a fundamental struggle taking place at the moment, which is that question of, are we going down the road of fear and loathing and surrendering our rights, or are we not? And I think there is a massive amount of propaganda coming out at the moment taking us in that position. I think it's a very deliberate political strategy of the government. A large part of the reason it's not on the agenda is because there is not a really strong opposition voice being put forward at the moment. And I think there's a lot to be done, and I'm not particularly taking a party political view, but I think what we need to do is try to push forward the opposition point of view. And part of the problem is, because it has become bipartisan, and I guess at this stage this is my sort of personal analysis rather than Amnesty, but what's happening at the moment is the Liberal government is trying to wedge Labor by going more and more and more and daring Labor to say no on the basis that they can then call them soft on terror. And Labor is so scared of being called soft on terror that they will just go along with everything. And because they go along, the government's then going, well, what's the next thing we can do? My God, they said yes to this one as well. Now we're going to have to go, they said yes to taking citizenship for dual citizens. They'll get that through, Labor will support it. Then they'll go, okay, now we want to start stripping citizenship from people who don't have dual citizenship. Will Labor, go that far? And I think there is a lot of, there is a struggle at the moment about Labor feeling that they cannot be seen to be soft. And that's part of that public debate. And we really need to get into that public debate saying we're sick of our rights being removed through this scare campaign. So to some extent we have to give opposition voices both this space, but also the courage to be able to say we're not just all going to be dragged down into this fear and loathing campaign. And then that's what brings the human rights agenda into play, and that's the narrative that has to be put forward. There has to be a counter-narrative to the fear and loathing narrative, and that has to be one about we do look after each other. We are people who consider each other and who work with each other and who care for one another, and that means we actually don't divide groups of us off and put them in camps and secretly abuse them. That has to be the counter-narrative that has to be given space out there, and those who are in political positions that in their heart oppose this have to be given the courage to actually stand up for what in their heart they know is right. And this is across parties, because there are people in the Liberal Party as well, I know, who are very uncomfortable with where the government's going. You recall under Howard, at least there was a group of people within the Liberal Party willing to stand up to Howard and willing to say, we will cross the floor. Those people still exist in the Liberal Party, but they fear that they don't have enough support to have the courage to present. So both, those people who are in those positions need the public to show them that they have the support, that they can have the courage to stand up and put that counter-narrative about looking after each other as opposed to living in fear and loathing. Elizabeth.
My name's Elizabeth Starlett. I have 2 questions. I promise they will be short. Those of you who have some learning of law would be familiar with the Latin phrase, lex injusta non est lex. What measures could we take to overturn laws that have been made that are clearly unjust? And my second question would be, would it be too hysterical to suggest that the current proposed laws to strip citizenship of suspected terrorists could later on down the track be extended to cover not only suspected terrorists, but other people who might perhaps be considered politically subversive or undesirable?
Slippery slope.
To answer your second question, I think the answer would have to be yes, and that's the point. Is that one attitude would be that this sort of thing is a thin edge of the wedge, and it's not really about who it's pointed at. It's a principle. It's a matter of principle. Whether it's a person that's supposed to be a terrorist or not a terrorist doesn't matter. As a matter of principle, laws which strip persons' citizenship without due process and for no good reason just shouldn't exist. Simple as that. Secondly, how do you get laws that violate human rights overturned? Lobbying, complaints, agitation at the United Nations. For example, laws with respect to homosexuality have, I think, in all states now gone. That was a long process. That was a group of people that complained to the United Nations, made complaints over and over again and lobbied for a long time. But that's how you do it.
My question's about political rights. I'm interested in the question of a Human Rights Act where political rights fit, particularly if we go back, the current government has the power, it seems, to declare certain organisations illegal because it accuses them of terrorism, whether the people have been involved in terrorism or not. How does that differ what happened in 1950 when Bob Menzies outlawed the Communist Party, which was struck down in the High Court and then put to a referendum, and with Doc Evatt leading the Labor Party, leading a very principled campaign against making anyone illegal? What's the difference there, and can that be enshrined in a Human Rights Act? What effect would that have?
I'm not sure I know the answer, but and Chris may be able to assist me, but there's an aspect of the terror laws that came in 2014 which provides for preemptive action. So back in the old days when you'd just have criminal laws, you'd get busted for doing something wrong. With the terror laws, you get in trouble if you think you might do it, before you do it, if you could be doing it. We're not really sure. Who knows? So it's the preemptive nature of the legislation. It is far-reaching.
It makes me very uncomfortable.
Yeah, it makes a lot of people uncomfortable. And so that's one of the considerable criticisms with it, certainly because of due process and assumptions of innocence. So that's probably the only answer I can offer you.
Yeah, so on the basis of political rights, so obviously freedom of association, freedom of speech are fundamental rights within the Universal Declaration of Human Rights, and they should be reflected. Obviously freedom of speech can be a complex argument, as we've seen with the arguments about the amendments to the Racial Discrimination Act, because a lot of human rights law and cases about human rights are about balancing competing rights. And that's essentially the argument about the Racial Discrimination Act, is about balancing the right to freedom of speech against the right not to be vilified. And that's a balancing act that we do all the time. So definitely I think the right to freedom of speech and the right to freedom of association are fundamental rights that should be reflected in any human rights legislation. The other comment about this, about the freedom of association stuff, is this is not just about terrorist groups. Try being a bikie in Queensland. You know, you can be jailed in Queensland for associating with named people. All you have to do is meet with them in a cafe and you can go to jail for that. So there are, you know, the expansion of those sorts of laws is underway. Now there's reasonable arguments about why you might declare an organisation that has been proven over and over again to engage in organised crime a criminal organisation. You know, we do have to be protected from organised crime, so that's not unreasonable. But my point is that that legislation in Queensland, which has been upheld by the courts, essentially started to say, well, okay, we're now saying that that the minister can prescribe organisations, and if you associate with that organisation, you can go to jail for it. Not for a criminal act, but for associating with those people. And that's a very dangerous road that we're heading down now. And it's not just terror organisations that we're now talking about. It has already expanded beyond the terror organisations into other organisations in our society.
Be aware in New South Wales there are what's called STMPs, Suspect Target Management Plans. What is that about? It is the police that apply a policy to often young people or to other persons, and they come under what's called an STMP. The impact of that means, for the police, they say they don't have to follow LEPRA, they don't have to follow the usual search and seizure legislation, the usual sorts of safeguards. And that's been around for a while. There is effectively, in my personal view, racial profiling going on every day with respect to young kids that are targeted by these so-called STMPs, Suspect Target Management Plans. That's been going on for a while. It's preemptive. You're Arabic, you're 15, you live at Bankstown. You're on a target. I'm a copper. I'm going to stop you every single day and frisk you. This is a reality of some kids' lives.
What about Amanda Vanstone helping out the mafia?
Furious.
Hi, thank you for your talk. Do you think the push or the fight for a Declaration of Human Rights in Australia, a Bill of Rights, a radical Bill of Rights, which encompasses so much, like real guarantees for a decent standard of living and shelter, could that be allied usefully with a rejuvenated, reinvigorated fight for an Australian republic? Would that be a useful way of pushing the agenda forward?
Very interesting perspective.
So, look, politically, I can understand where you're coming from in terms of aligning forces that might be there. With my Amnesty hat on, I'd be saying Amnesty's not really interested in what political systems are in place. Amnesty's interest is in human rights being observed regardless of whether it's a republic, whether it's a monarchy, whether it's a theocracy, regardless of what the political system is. Every political system should observe human rights. So, you know, Amnesty, I can tell you, is not going to go down the road of the republic. It's not what they would put into the list of human rights issues that it would campaign on. But having said that, I can understand the perspective that says, well, there are times when people have right interests that come together and can work together. And so I can understand from that perspective where you're coming from.
The politics of agency, how to make it happen.
Okay, one final question, thank you.
Well, my question's about Gillian Triggs. I'd like some insider information, some gossip if I can. Why is the media, or particularly the Murdoch media, zooming into her? Why is the Liberal Party zooming into her? And what are the ramifications long term of this sort of assault on her role in the Human Rights Commission?
Disgusting behaviour.
Just a couple of things on why, and I'll hand over to Louise after, but a couple of things on why the media, and particularly the Murdoch media, are taking the position they're taking. What's really interesting about the attack on Gillian Triggs is that the report that she wrote was given to the government months before they tabled it. And what they did was clearly a political strategy that said, we must attack the messenger. And they held the report back as long as they could, and in the meantime they started a campaign of attacking Triggs personally. of attacking her alleged political affiliations, attacking her private life, attacking her personally, leading up to them finally releasing the report. So it was clearly a preemptive strategy of, we know this report is damaging, but what we don't want the media to focus on is what's in the report. We want the media to focus on Gillian Triggs. And it was a very successful strategy. And obviously the government works very closely with the Murdoch media. Probably the best example of that was where the Prime Minister got himself in a bit of trouble, where he denied that he'd leaked the citizenship stuff to the Telegraph in the Cabinet, and it appeared in the Telegraph the next day, because it had clearly been leaked to the Telegraph. There is a very close relationship, as there is in all governments, between senior ministers who will give things to privileged access to the media, and the media rely on that privileged access. Journalists rely on having privileged access in order to get stories. And to some extent what happens in that relationship, and I've worked in political offices and as a media officer for politicians, I know there is a relationship there which essentially says, if you want to continue to get privileged access, you give us the sort of coverage we want. It's part of the relationship between senior journalists and senior government ministers. And so I think part of that is that the media was given that privileged access on the basis that they would run the government's agenda of diverting attention away from the content of Triggs' report and focusing it on Triggs herself. And so most of the media coverage, if you go back and search the media coverage after her report came down, the vast bulk of it was on Gillian Triggs herself and whether she was biased, and the government's attacks on her and the calls for her resignation, etc. There was very little coverage of the content of the report.
It's about scuttling the office. It was about scuttling the human rights debate in this country, and the best way to do it was to attack her, sadly. Although she did appear on Q&A, so...
Yes.
Our cinematographer, Catherine, wants to ask a question, so I'm going to become the deputy cinematographer while she does that.
Oh, thank you so much.
So we had a little chat about the NDAA, and despite America having a Bill of Rights, it was still impossible to get an injunction. I'm talking about Chris Hedges versus Obama, and how Judge Catherine Forrest put an injunction on this. The NDAA, post 9/11 law, permits people to be arrested, not having committed any crime, and locked away indefinitely. Now, here and in America, the phrase is always in the interest of national security, and it seems to me that that is starting to override our judicial system. And I think that's the argument. You're going to have to find an argument, lawyers, that will override in the interest of national security. And I think the problem, the reason that we have bipartisanship, is that none of these politicians really know what's going on. And in fact, they are just relaying the fear and the messages that have been generated by national security agencies. And we're talking about the NSA, who were there trying to stop the injunction. Their lawyers were there trying to overthrow this injunction on the NDAA. But it's happening here as well. And so I'm just wondering what kind of argument that you bring forward. Is it about scientific method? Is it about examining all the evidence, our right to actually have evidence about us publicly scrutinised? Because at the moment, Brandis and a lot of others are just saying, in the interest of national security, we are going to take away people's citizenship, and nobody really has the right to know what the evidence is.
As barristers working every day in both the criminal and civil jurisdiction, I don't do criminal work anymore, but I do civil work, you are consistently confronted with arguments that it's not in the public interest to disclose documents. And all you can do is just argue the point. In the criminal jurisdiction during the terrorist trials, my understanding was that there was considerable difficulty to get access to documents. But all you can do is argue the point.
Yeah. Well, might I just add, it was revealed that the CIA constructed the whole story of Al-Qaeda, and it was really about getting their budget for the next season. So can we rely on the things that we're not allowed to know about?
No, I don't think we can.
I guess a quick comment on that. So one of them is undoubtedly the national security state is an issue. Like if you look at the amount of resources that have gone into, in Australia, the massive increase in the budget of security institutions in this country, it's huge. I mean, ASIO is funded at 3 to 4 times the level that it used to be funded at. I don't actually think it comes down to lawyers being able to argue the case. I mean, the courts have tended to go along with the national security argument. It comes down to what I was saying before about whether we, the public, are willing to live in fear. And part of the problem with that, and I have some sympathy for politicians, because what they do is they say, look, if we go too far that way on rights, you know, we don't really cop that much flack for that. You know, a few criminals get locked up, we lock asylum seekers up, they don't vote anyway. But if a terrorist incident happens, we'll be held responsible for it and we will lose massive votes. So they're making a judgment on where they think the public is at. And that's the issue for me, is that's why I've been saying it's about whether we choose to live in fear or we choose not to live in fear. Because ultimately there's a political solution to this, not a legal solution to this. Yes. And it is that we have to say we will not be cowed in this way. And the other thing I've got to say about those institutions working for Amnesty, it was thanks to the Snowden revelations. I'm pleased to know that both Australian, American and UK security services routinely read my emails and listen to our phone conversations. That makes me feel much more secure, knowing that that's happening, and I regularly say hello to ASIO when I'm on the phone. But that's the thing. I'll say hello for you as well. But that is not the way we actually have a sense of security in our lives. Being monitored and observed and surveilled in that way does not make me feel safer. And we have to say we're not putting up with that, we're not going to live in fear, we're not going to be cowed, we're not going to go along with this stuff. And ultimately the solution is a political one, it's not a legal one.
Thank you.